colonial justice. It stung so much that they wanted to protect every American citizen from that kind of treatment, even if they might be hiding something, even if they weren't heroic figures. Precisely why the Fifth Amendment was there. So, Mr. Koskinen, there are some of us here who wish you well and will certainly cooperate with you and try to make sure yours is a successful tenure. Obviously, to the extent that you can cooperate even more fully with this committee, that would be welcome. But be aware that unfortunately this committee has a habit sometimes of cherry-picking facts and of leaking. I heard the chairman complain about the IRS actually leaking documents. My. That would be a terrible thing if true. Certainly not something we ever do in this committee. But just in case, be prepared, because that may happen to you too. So thank you for your cooperation, but be on your guard, because there's something else at work here. I yield back.
I want to thank the Attorney General for the good work he does. I know he is aided with great skill by two former Schumer employees who work for you, Elliot Williams, who's been gone for a while, and Brian Fallon, who we miss very much and is doing a good job for you. That's our comment.
Thank you, Senator Schumer.
Okay.
The president, to his credit, agrees that this is a terrible abuse. He called the IRS scandal intolerable and inexcusable, and he called for those guilty of this misconduct to be held accountable. But when your department was asked to step in and investigate, no one has been held accountable for this abuse. In fact, your department installed a political donor of the president's to lead the investigation. Appointing a political donor to investigate a political activity calls the entire investigation into question.
We're still trying to find out who. And the president, may not know anything about why this happened, but we do know, I think we proved today, that one of his political appointees did know. Would you both agree with that? That this was going on, that this targeting was going on?
I have no factual basis to agree or disagree.
Okay, the chief counsel is a political appointee, correct?
From what I understand, that is
Is
correct.
that your understanding, Mr. Hull?
Yes.
And you both have testified that these cases were sent to the chief counsel's office?
Yes.
I was just made aware of that recently.
Okay, so at any rate, there does seem to be somebody who doesn't want the truth to come out, because if there was nothing wrong done here, then we wouldn't be sitting here today. We wouldn't continue to have these hearings. Do you agree with that?
I have no knowledge of such a situation, sir.
Okay. Did you have a special expertise, Ms. Hofker, in this area of Tea Party organizations or this type of case you were asked to do?
I had no specific expertise in political organizations.
Any idea why you were assigned that?
At the time, it was identified by management as an emerging issue, and I was the emerging issue coordinator, so consequently, I was assigned the cases.
As you were doing these cases, both of you, did it ever dawn on you that this is kind of strange, there's something weird going on here, that this is abnormal, maybe I should suggest this to someone?
I did. I think that's the fact that I pursued another job is evidence of that.
Mr.
I have not done anything wrong. I have not broken any laws. I have not violated any IRS rules or regulations, and I have not provided false information to this or any other congressional committee. And while I would very much like to answer the committee's questions today, I've been advised by my counsel to assert my constitutional right not to testify or answer questions related to the subject matter of this hearing. After very careful consideration, I've decided to follow my counsel's advice and not testify or answer any of the questions today. Because I'm asserting my right not to testify, I know that some people will assume that I've done something wrong. I have not. One of the basic functions of the Fifth Amendment is to protect innocent individuals, and that is the protection I'm invoking today. Thank you.
Called out the Supreme Court regarding the Citizens United decision. That same year, 2010, the president numerous times talked about Tea Party groups as shadowy groups who would hurt our democracy. That same year, Senator Schumer says we're going to get to the bottom of this, encourages the IRS to investigate. Senator Baucus, that same year, asked the IRS to investigate C4 applications and C4 groups. Senator Durbin asked the IRS to investigate Crossroads GPS. And then, in that same year, 2010, 2 weeks before the election, October 19th, at Duke University, Lois Lerner gives a speech. And she says this: the Supreme Court dealt a huge blow in the Citizens United decision. And everyone is up in arms because they don't like it. They want the IRS to fix the problem. The IRS laws are not set up to fix the problem. C4s can do straight political activity. So everybody is screaming at us right now. Who's everybody? Everybody is not everybody. Everybody is the president and Democrat senators who ask her to do something. Fix it now before the election. Lois Lerner says, I can't do anything right now. She couldn't fix it before the 2010 midterm election, but what she could do is start a project to deal with it in the future, and that's exactly what she did. That same fall, she sent an email, again, just weeks before the midterm election. Lerner tells her colleagues, let's do a C4 project next year. But she also says we need to be cautious so it isn't a per se political project. In fact, the chairman put this email up in our last hearing. Per se political project means that's code for it is a political project. We just have to make it look like it's not a political project. Then in early 2011, Lois Lerner orders the multi-tiered review of C4 applications. Multi-tiered review, you know what that is? That's code for we're going to delay, we're going to harass, we're never going to approve these people, we're going to make it difficult. That's part of the C4 project. And then make no mistake, she put Washington in charge. This email is also one that the chairman put up at our last meeting, where Lois Lerner said this in February of 2011. Tea Party matter, very dangerous. Cincy should probably not have these cases. So this narrative about Cincinnati line agents in Cincinnati doing this is completely false. She ordered them not to have these cases. And then what happened? Lois Lerner got caught with her hand in the cookie jar. Tea Party groups came to us and said, we're being harassed. We asked for the Inspector General to do an investigation. He did the audit, and then before he can release the audit, unprecedented, before he releases the audit, Lois Lerner, in a speech in front of the Bar Association here in this town, with a planted question from a friend, reveals that, yes, targeting was taking place. And what'd she do? She throws the Cincinnati people under the bus. The very people she said shouldn't have the cases, she throws them, good civil servants, she throws them under the bus. And here's the real kicker. Lois Lerner, who did this project from the pressure from the president and Democrat senators who did this project, she won't talk to us. She won't talk to us, and our witness today won't give us her emails, even though we subpoenaed them over 6 months ago. That's what, Mr. Chairman, Lois Lerner won't talk to us. She'll talk to the Justice Department because she knows that investigation. She'll talk to the people who can put her in jail, but she won't talk to us, and the guy who can give us the emails won't give us the emails. And here's why today's hearing is so important. The C4 rule that's being proposed, that got 149,000 comments, would codify what Lois Lerner put into practice. Would in fact accomplish the goal that she set out to do in 2010. The C4 rule, we had a hearing 3 weeks ago, Mr. Chairman. We had a hearing 3 weeks ago where we had the ACLU, Tea Party Patriots, the Motorcyclist Association of America, and the Homeschool Legal Defense. All 4 of those groups came to that hearing, and you know what they all said? This rule stinks and should be thrown out. Now think about that. From the ACLU to the Tea Party, from homeschoolers to Harley riders, everyone knows this rule stinks. Everyone knows except the IRS.
The IG, as you know, wasn't aware of the speech at Duke University, in which it was clear that Lois Lerner was saying in pretty plain terms that she was going to act on what the FEC couldn't act on. So this is part of the investigation. It's the reason we've asked for all, and quite frankly, it takes a lot less time to just go through and view these things and say, oh, that's got no 6103, and you just start sending it. And that's what we had hoped for when we issued the subpoenas for all, because these are people, as you know, who have said things before a committee or failed to say things in some cases, in which they become what law enforcement might call a person of interest. And Lois Lerner and Holly Paz and so on, and the other individuals are people of interest because of their possible role.
So in other words, any email with anybody talking to their daughter if there's any relevance whatsoever, if they say, I just don't like Democrats. I mean, and say that was in any way you could connect that with an investigation, and they're talking to their daughter.
No, I appreciate that.
I'm just trying to make sure I
But I
understand
just
that.
want to make sure the context.
Yeah.
These are government emails from a government account, back in and out. This is the use of IRS assets to communicate. We would presume that the majority of it is not shopping online. As a matter of fact, in the case of Lois Lerner, she did her shopping online in a Hotmail account, which she also did 6103 material on. So, you know, in a normal case, this would not be something you'd look through, but we and the Department of Justice, if they're actually doing the investigation they claim to, we have an obligation to look and figure out whether we can opt out these communications, which in this case were always the product of the government, always available. And as you know, it is a given that communication on government computers is in fact open to government review.
I just wanted to make sure the public understands that.
Thank you. Mr. Connolly.
Thank you, Mr. Chairman. I would say to the ranking member, sounds like his understanding is correct. And I would hope we do the same with, I don't know, the IG, Mr. Russell George. I'd like to see all of his overt partisan political emails. I'd like to see if he's emailed relatives, if he's emailed staff members of this committee. I think that would be relevant to putting in context his findings.
Considered tea parties were provided to TikTok last week on July 9th, 2013. They were not provided during our audit, even though similar documents that quote Tea Party, unquote, but not progressive were. I am very disturbed that these documents were not provided to our auditors at the outset, and we are currently reviewing this issue. To follow up on the information that other terms like, quote, progressive and occupy, unquote, appeared in various sections of the BOLO list, we conducted additional analyses to provide you, members of Congress, with the data that we have due to the interest in this issue. However, we do not have full audit findings on the use of these other criteria. With respect to the 298 cases that the IRS selected for political review, as of the end of May 2012, 3 have the word progressive in the organization's name. Another 4 were used, quote, progress, unquote. None of the 298 cases selected by the IRS as of May 2012 used the name Occupy.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And I'll recognize myself for a round of questioning. Did you need to upgrade your computers in order to produce all of Lois Lerner's emails?
I'm sorry, could you?
Did you need to upgrade your computers to produce all of Lois Lerner's emails?
We have to upgrade our computers to produce all of the emails and documents.
Commissioner, I appreciate that, and my time is limited. And I recently pulled all of my emails off of the House computers. It took one person at House Call a very small part of a morning to gin it up and produce it. I understand it takes a while to go through them, but if I'm correct, in a matter of hours, not after we subpoenaed, but after we showed interest, your agency had taken all of Lois Lerner's, all of Holly Paw's, all of William Wilkins, all of Jonathan Davis, former chief of staff, all of the White, or maybe not all of them pertaining to the White House, but the first 4 take a matter of minutes to do. So my question is, our subpoena, which is not extensive, for those 4 particularly, asked for information, asked for all the emails that somebody who has, in the emails we've seen, both government and non-government emails in some cases, acted overtly political in her speeches and her activities, including what Mr. Jordan quoted. We asked for all of her emails. Do you have any privilege or any reason that you can't and shouldn't have delivered that months ago?
you seem to have more information about this than I do. We have 90,000 employees, and my understanding of the process is that to go through all of those emails, which are millions of emails, to make sure we have not only the outgoing emails, but the incoming emails, is not a matter of a few minutes or a few hours. But in any event, we have provided for all of those people, or in the process of providing, all of the information and all of the
Commissioner,
related to the determinations process, and we have
Commissioner, that is not the subpoena. And I want to be very clear. We issued you lawful subpoenas because you didn't cooperate based on letters. Our subpoena says all of Lois Lerner's emails. Is it your position today that you intend to give us those responsive to some key search word, or you intend to give us all of Lois Lerner's emails, all of Holly Paz's emails, all of William Wilkins's emails, all of Jonathan Davis's emails?
We are working through the process. We have never said we would not provide those. We are anxious, as I have said.
Will you provide all of the emails for those 4 individuals?
We will provide you. We are actually trying to, in an orderly way, conclude the investigation on the determination process, which is what the IG report reported to. We've had over 250 people at various times working on this investigation. We are producing emails. You will get email copies today, redacted, and you will continue to get them. Our hope is that you could concentrate on the determination process. GAO is already at the congressional request doing a review, starting a review on the examination process. As I've said in my letters to you.
No, Commissioner, you said something, and I want to focus on that. You said your hope is that we would focus on the determination process.
I can't tell you what to focus on.
Thank you. We are focusing on those individuals. We have asked for all of their emails in a legal subpoena. My question to you today, will you commit here today to provide all of the emails? Not all the emails you believe are responsive, not all the emails you choose to give, not all the emails that are other than embarrassing, all of the emails.
Mr. Chairman, we are prepared to continue to work with your staff. As you can understand, when you say all of the emails, you're going to get hundreds of thousands of pages of irrelevant documents.
No, I'm sorry. Lois Lerner is an individual. We're asking for all of her emails. She obviously had a limited amount of emails. Quite frankly, we asked for all the emails. We believe that the emails, for example, where she talked about the outcome of the Senate races maintaining Democratic control because of Indiana and other states, the outcome of the Maryland pro-gay initiative, all of those are responsive to who she was and why she did what she did. Therefore, we have asked for, in the case of these individuals, all of their emails. Holly Paz, for example, said she didn't know what Citizens United was. Well, Lois Lerner made it clear that she was trying to find a way to enforce around Citizens United at the IRS, and we've already seen the documents for that. Will you today commit to deliver all of the emails, not all that you think are responsive, all that the 4 squares that any lawyer can read of the subpoena says we're asking for, which is all the emails for Lois Lerner, all the emails for Holly Paz, all the emails for William Davis, and all the emails for Wilkins, and Jonathan Davis. Now, these are all of the ins and outs from their mailboxes. It's not difficult. You already have pulled them. There's no question at all. It's a question of will you deliver them.
Mr. Chairman, we're happy to continue to work with you, and we will advise you. I'm not aware that we have pulled them all, but to the extent we have, they all have to be redacted, and we will work with you and advise you as to what the volume is. The reason the search terms were selected, they were selected by committee staff here and in the other investigations so that
your people, and my time has expired, you've previously selected search terms, asked us to give priority. That's all fine. The subpoena that was personally delivered to you, which we expect you to comply with or potentially be held in contempt, those emails were very specific based on individuals who have become specific focus on why they did what they did and what they have said, whether it's true or not, is critical to this committee's discovery of intent. Will you commit to deliver all of those emails, redacted only for 6103?
Yes, I'm as I say, we've never said we wouldn't produce those emails. The search terms, just to clear the record, were not selected by the IRS. They were in fact selected in cooperation with the various congressional investigations on the House and Senate side to try to limit the volume of material you're going to get. We will be happy to provide you volumes of material.
My time has expired, but let me make it clear in closing. It does not take any search terms to respond to all the emails of Lois Lerner.
You're going to get a lot of emails, and as noted earlier, you may want to have this investigation go on forever. We have provided you all of the emails relevant to the IG report. We are providing you Lois Lerner's emails with regard to issues that you've raised about the examination process, about the appeals process, and about the regulatory process. Minutes. I don't know, but I don't think it's minutes.
I mean, that's one of the brilliance of the email system is you go in and you check the sent box and the inbox, and you suddenly have all the emails, correct?
Right. They get taken off and stored in servers, and you've got 90,000 employees, and you've got...
I know, I'm not asking to search. I'm asking to find one. They type in her email address.
We could find, and we in fact are searching, we can find Lois Lerner's emails.
And how long? How long would that take?
I have no idea how long.
Would it take a day?
As I said, I have no idea.
Well, I just don't understand. You got a duly issued subpoena. If you were in the private sector and somebody was issued a subpoena and you didn't comply with it, what would happen to you?
For this subpoena, the court would actually rule that it's far too...
Oh, so you're going to make the determination.
No, the court,
you're going to make
you asked the question. Let me answer the question. In a court of law, if you provided that subpoena, a judge would not enforce it because...
Wait, now stop right there. So you're going to be the judge.
I'm not being the judge. I'm just telling you what would
happen. Yes, you are.
You asked me...
You have a duly issued subpoena. Are you or are you not going to provide this committee the emails as indicated in this subpoena? Yes or no?
We have never said we wouldn't...
I'm asking you yes or no.
We are going to respond to the subpoena.
No, sir.
Yes, we are going to respond to the subpoena. I'm just telling you, to respond fully to the subpoena, we're going to be at this for years, not months. That's the only thing I'd like to...
And I don't understand that. Just specific to item 1, Lois Lerner.
Lois Lerner...
Sir, are you or are you not going to provide this committee all of Lois Lerner's emails?
We are already
starting
the process. Yes, we will do that.
Yes, and then by when? When can we have that?
I can only tell you it's going to take me, my group, I asked this question, just to get you the Lois Lerner emails, redacted, because you have to get them redacted, for examinations, appeals, and the...
No. Is that what the subpoena says?
Would you like to hear the answer to that?
No, I'd like to know if you're going to fully comply with the subpoena. Not your version of the subpoena, the actual subpoena.
You asked me how long it would take to respond to the Lois Lerner emails. I'm explaining to you why it's going to take time, just to respond to the categorization.
I don't want you to redact it. I don't want you to take the certain categories that you want. That's not what this duly issued subpoena says.
I'm telling you, just to supply the Lois Lerner emails, which we are going to supply for examinations.
No.
Can I answer the question?
That's no, sir. When it says all emails, why are you qualifying that? Under what authority do you change this subpoena?
I was not qualifying. You were asking how long it was going to take, and I was giving you an example of why it's going to take a long time, because we have to redact out of those emails all of the 6103 information. We're working very hard to get you the Lois Lerner emails. It's going to take us several weeks to get you the Lois Lerner emails for examinations, appeals.
Wait. Why are you getting us for just it'd be easier to just give them to us all, right?
I know, it'd just take a lot longer because we have to redact the rest of them. They're there. We actually selected those because in a letter from the Ways and Means Committee also saying they need help, they focused on what they're looking for is those categories. So prioritizing, we said we'd provide both
the gentleman
with those categories.
Expired.
We're happy to provide you the rest of them.
I'm yielding back, but this commissioner has no intention of fully complying with this duly issued subpoena. That's the case. That's where both of us, on both sides of the aisle, need to stand up for the integrity of the House of Representatives. When you have a duly issued subpoena, you comply with it. It's not optional.
Thank the gentleman. I think that all time is expired. The gentleman from Maryland has
unanimous consent, just for a minute.
Unanimous consent, 1 minute.
Mr. Chairman, I never heard the commissioner say that he was not going to obey the subpoena. As a matter of fact, that's all he's been saying.
Actually, if the gentleman would yield, he has on every single question failed to say, yes, I will give you all the emails. He has gone into the ones that he is prepared to give, the ones that he could give to Ways and Means in an hour, because once you do the search, you just dump it to them. You know, and even then he said that those would take, the ones that he says he's going to give us, he said it would take a couple weeks, and of course the subpoena is many months old.
Well, let me just say, what I'm reclaiming just for a second. I just want us to be clear. I mean, you know, time is precious, money is precious. Just tell us, I mean, you talk about relevance. You said if a lawyer were to see the subpoena, they would have some concerns. I just want them to be clear. I mean, it sounds like, again, I'm saying that what I said before. You seem to have an understanding, and we seem to have an understanding, and they don't seem to be the same. So are you going to provide the documents for Lois Lerner?
Yes.
That were subpoenaed?
Yes.
And how long will that take?
I do not know. I know it's going to take us several weeks. I asked that question yesterday, simply for the categories we're already working on, and I was told that to redact those will take us several weeks longer.
Right.
It will take us much longer than that, but we will provide them. And I've said with regard, notwithstanding the congressman who's now departed, view that we're not going to comply. We are going to comply. We've said and never said we wouldn't comply. We are simply trying to help refine the search so that in fact we could get this done sometime in the near future, that is this year. But at the rate we're going, if as noted by an earlier question, if you want all the categories of all the applications of everybody who's been through the C4 process for the last 4 years, we can do that and we will do that, but it's going to take years.
Very well. Thank you.
I thank the gentleman. I thank you for your questions. But you know, hopefully we all understand that asking for all the emails, the ones that you seem to be least willing to put first, are the ones that probably have no 6103. They're very quick to go through, and somebody simply looks and says, "Oh, she's talking to an outside entity. By definition, there can't be any 6103 there, right?"
Correct. All the ones that are easy are easy. The ones that are difficult, and there are more of the difficult ones than we'd all like.
And of course, the ones that the gentleman was asking for before he had to leave were the ones that were not being given, which by definition very often are easy.
Right. And I would just note for the record that all of the Lois emails we're talking about redacting have been provided already to the House Ways and Means Committee and the Senate Finance Committee because they don't have to be redacted. So there's been no question there about, in fact, the fulsome response.